Hello, this is John Milburn for Laws 13010 Evidence and Proof, and this is the pre-recorded session for Week 7, Term 3, 2018-2019. Thank you for attending, and this is in lieu of the live session that we would otherwise have on Thursday the 3rd of January 2019. So the next live session will be on Thursday the 10th of January 2019 at 7 p.m. So we look forward to seeing you there for that live session. This week, we're going to deal with a continuation of the issues that we discussed last week, and starting with issues to do with Jones and Dunkel. But just an advance reminder and also an announcement, an apology almost. You will receive your results for the first assessment soon. And I do thank you for the work that you conducted with me in the live examination and cross-examination exercise. I have completed the task. I haven't yet uploaded the results. The experiential assessment is due on the 24th of January 2019 at 11:45 p.m. Now that's worth 30%, as was the case with the first assessment. And as usual with me, the rule applies that there is a cut-off date. So you have 9 days within which to lodge that assessment. If you're late, you'll lose 5% per day, subject to the cut-off at day 9. After that, I won't receive any further assessment work. So please complete that task and have it uploaded before the assessment is due to avoid any issues. Remember, of course, you can apply for an extension, but bear in mind that one of the things that I must consider is how long have you known about that assessment and the date by which it's due. And of course, you're aware of the assessment and the date that it was due on week 1. So by that stage, we'll be in about week 9. So it's very difficult to justify an extension if, for example, you aren't feeling well during that week. I hope you understand. Now let's go back to our discussion on Jones and Dunkel. And you recall that Jones and Dunkel applies strictly in relation to criminal law cases. It does have some degree of applicability to criminal law cases, and you'll recall the discussion on Weissensteiner against the Queen. In short, Jones and Dunkel provides that if a witness is material to a particular matter and a party chooses not to call that witness, whether the court can make an adverse or the arbiter of fact is entitled to draw some inference against that party for failing to lead the evidence that would otherwise logically be produced in support of a particular claim. One question arises in relation to the context more of well, civil and criminal, but to do with the Crown, and the question of whether that rule applies to the Crown. The leading case is Apostolides. It's Crown against Apostolides, Apostilides, 1984, 154 CLR 563. In that case, the High Court held that a trial judge cannot compel the Crown to call a witness. Now, a judge, in fact, can call a witness, but should do so only in the most exceptional of circumstances. I've never seen that happen in practice. It's never been involved in a case of mine. But let's consider Apostolides, and what does that lead us with? Now, in a criminal law context, the Crown use Apostolides as the authority for the proposition that it need not call all witnesses, even if those witnesses have come forward and provided a statement, and even if that statement has been provided as it should be to defence. The Crown is entitled to say, for example, that we do not believe it is appropriate to call this particular witness because the witness, the testimony is tainted or some other good reason. The court can't compel the Crown to call that witness, and the court is very unlikely to call that witness to give evidence. So that means it falls back on to defence, and defence have a choice. They can call that witness because there's no property in a witness, or they can proceed without that witness being called at all. Bear in mind, of course, that the Crown has an obligation to comply with model litigant principles. By that I mean that there are guidelines whereby the Crown is required to present a case fairly and not to press for a conviction, for example, at all costs. So if you're dealing with anything to do with evidence, or you're completing an assessment that relates to evidence, I would urge you, amongst other things, to consider the model litigant principles and procedures, and you may have some success in looking on Crown Law websites or DPP websites in relation to those issues. Let's move on to a different topic now, and that is the general concepts relating to compellability and competence of witnesses in criminal cases other than the accused. Starting first with the co-accused. Now, there are a few sections of legislation that you need to consider. The first I'll refer you to is Section 8 of the Queensland Evidence Act, that is Evidence Act 1977. And the use of the word defence in Section 8 of that Act means that in cases where there is more than one accused, each can give favourable evidence to one or more of the co-accused. Favourable evidence. However, there are a few riders to all this. The first is that co-accused cannot be compelled to testify for any co-accused. And the second is this: it's quite common for co-accused to turn on each other. And the defence that they might run is what we call a cutthroat defence, meaning wasn't me, it was him or it was her. So a co-accused in a cutthroat defence is not even a competent witness for the Crown against a co-accused if they're still co-accused, although the evidence that they give on their own behalf during such a cutthroat defence may well be of advantage to the Crown generally. So co-accused are not compellable, and they're not even competent in some circumstances. What that means in practice is this: that where, for example, a co-accused indicates that he or she is going to enter a plea of guilty, and in mitigation point the finger, as it were, at a co-accused, then the sentence of that person must take place prior to the trial of the co-accused or co-accused, or a number of co-accused who enter pleas of not guilty. And the first party, who has now been sentenced, comes along to the trial and is then competent and compellable to give evidence for the Crown, because they're no longer co-accused. I hope you understand that subtle distinction. In other words, the rules change once the parties cease to be co-accused. And the reason for that is that if you look at Section 8, subsection 1 of the Evidence Act, it talks about person charged, and that means in the context of the current trial. The next relevant section for you to consider is from the Criminal Code, Queensland, and it's Section 632. That's a section that deals with corroboration. And a person may be convicted of an offence on the uncorroborated testimony of one witness unless the code expressly provides to the contrary. So think about that. The uncorroborated testimony of one witness alone is sufficient to justify a conviction of a criminal offence that is beyond all reasonable doubt. If you think about that, that's most likely going to be the uncorroborated testimony of a person who was associated with the accused in the context of the criminal activity. Otherwise, it's difficult to envisage a circumstance where the uncorroborated testimony of one witness would be sufficient. It's not impossible, but it would normally be a co-accused. So that's why I'm mentioning this section within this context. On the trial of a person for an offence, Section 632 of the Code says a judge is not required by any rule of law or practice to warn the jury that it is unsafe to convict the accused on the uncorroborated testimony of one witness. So think about that for a sec. So not only is it possible for a jury, for example, as the arbiter of fact, to find the guilt of a person beyond all reasonable doubt based on the uncorroborated evidence of one witness alone, the judge is not allowed, a judge is not required, rather, by rule of law to warn the jury that it is unsafe to convict on the uncorroborated testimony of only one witness. Subsections 1 and 2 of that section 632 do not prevent a judge from making a comment on the evidence given in a trial that is appropriate for the judge to make in the interests of justice. So the judge may make a comment, but is not required to make a comment in those circumstances. But there's an important rider to this, and that is that the judge is not allowed to warn or even suggest to the jury that the law regards any class of person as an unreliable witness. And that can be relevant in the context of complainants, particularly those complainants in sexual offences which are historic, or children, or people with disabilities, or parties that were in a relationship, any of those sorts of class of persons. The judge may not warn or suggest that they're unreliable witnesses. In the case of historical offences, the judge may warn about the inherent difficulties caused to defence as a result of proceeding with a trial now in relation to allegations from many years ago. And the way to do that is for defence to ask the judge to provide the jury with what's called a Longman direction. And you'd be aware of that from what we've discussed previously, and you'd be aware that a likely place to look for that direction and commentary about it would be the bench books. Now, the third piece of legislation that I wish to bring to your attention, it's in your textbook, about co-accused, is Section 17 of the Evidence Act Commonwealth. That section refers to a co-accused as an associate defendant and says that an associate defendant is not compellable to give evidence for or against a defendant unless they've been tried separately. And Section 17, subsection 4, requires the trial judge to be made aware of that fact before they choose to do so. So what does that mean? It means an associate defendant is competent but not compellable to testify on their own account or in favour of a fellow accused or for the Crown. And finally, within this area, we'll talk about a spouse of a criminal accused. The starting point, again, the Evidence Act, Queensland, look at Section 8, subsection 2. And it simply states this, that an accused is both competent and compellable as a witness, that the spouse of an accused, for both the Crown and defence, whether the accused consents or not. Now, it's a little more complex than the Commonwealth jurisdiction. Have a look at Section 18 of the Act, and it provides a privilege, effectively a privilege, to spouses in some circumstances. Have a look at Section 18, subsection 6, and it provides that if the witness were to give evidence and there would be a likelihood of direct or indirect harm being caused to the relationship between the witness and the accused, and the court assessed that that outweighs the desirability of having the evidence being given, then the court may exclude the evidence. And Section 19 goes on to abrogate the privilege in cases involving what might be broadly described as domestic violence cases. So the general principles are competent and compellable. The Queensland Act doesn't go anywhere near as far as the Commonwealth legislation. Commonwealth look at Sections 18 and 19, and in the Queensland, look at Section 8. Now let's change tack a bit and talk about a general concept of privilege. So we've talked at various stages about people being able to claim a privilege, for example, against self-incrimination. So a person who is otherwise compellable may sometimes be relieved of this obligation to answer a question, or a line of questions if you like, because the law regards them as having a privilege against doing so. And it's all based around fairness and justice. In other words, the primary ones, the privilege against self-incrimination, and another, the privilege to promote confidentiality, legal professional privilege, which is such a current topic given the issues surrounding a barrister in another jurisdiction having disclosed confidential privileged information to the Crown in criminal proceedings. I'm sure you're well aware of that case. But even though there are these general privileges that apply, the law does need to accommodate between competing interests. That is, the desire for truth against the desire to uphold privacy. And the nature and extent of the privilege does change from time to time. Now, again, in your notes, have a look at a case, Environment Protection Authority against Caltex Refining, Pty Ltd. That's 1993, 178 CLR 477. The High Court in that case refused to extend the privilege against self-incrimination to corporations, and it acknowledged in doing so the problems previously experienced in society from fraud perpetrated behind the cover of what we call the corporate veil. Now, of course, you're all aware of the privilege against self-incrimination, which is really part of the right to silence. And that's the basis upon which an accused person can never be compelled to testify at their own trial. Have a look at Section 15 of the Queensland Evidence Act. But there are a few interesting things about this. The first is we don't have a general body of law that provides for these rights. We don't have a Bill of Rights. And the privilege is not guaranteed under the Australian Constitution. It's not confined to criminal trials. It may be claimed in court proceedings in other circumstances or even tribunals or commissions. But there are some guidelines that generally apply. So have a look at a case of Jattan, Jattan, against the Chief Executive, Queensland Health, 2010-237, FLR 360. The court held that a pharmacist who'd been forced to testify before the Australian Crime Commission, just on that basis, the Australian Crime Commission, the Crime and Corruption Commission, do conduct what are essentially proceedings where a person is compelled to answer, even if it means to incriminate themselves in doing so. But it usually comes with a guarantee or statutory guarantee. So in the case of Jattan, the statutory guarantee was that his evidence could not be used against him in any proceedings for the imposition of a penalty. Now, the question was whether he was entitled to invoke that protection when the state regulatory authority commenced a process designed to deprive him of his power to endorse and dispense drugs. Also look at Boyes' case. That's Crown against Boyes, Boyes. This is an old case, 1861, 121 ER 730, and the court established the classic test of whether the witness may legitimately claim privilege, and the question was whether there was a real and appreciable danger of prosecution. So the issue then is, well, what if someone has not been prosecuted, but can they claim privilege outside of or potentially before prosecution, have a look at the boys' test in that regard. But I need to temper all of these statements by saying this, that in practice, the privilege against self-incrimination does not mean that you have, as it were, a get-out-of-jail-free card. It's always open for prosecution to prove your guilt in other ways. And that makes entire sense, doesn't it? So fingerprints, DNA samples, etc. Witness accounts of independent witnesses, other things might prove to be incriminating, even if there's no admission of guilt. And in fact, I'd say that that would be the majority of cases. So if a person has been compelled to make statements against their own interest in those type of proceedings where they are compelled to give an answer, then whilst prosecution cannot use that admission in criminal proceedings, they can still find enough evidence, potentially, to prove to the satisfaction of a jury beyond reasonable doubt that the person is guilty. So it might be through using real evidence, DNA, fingerprints, other witnesses, etc. Okay, let's have a look at the Queensland position and the privilege against self-incrimination. The starting point is Section 10 of the Evidence Act. And it says that nothing in the Act shall render any person compellable to answer any question tending to criminate the person. However, as always, there are some rules that go with that. In criminal proceedings where a person does give evidence, the person's liability to answer questions is then governed by Section 15 of the Act. So Section 15 of the Queensland Evidence Act deals with the issue of questioning a person charged in criminal proceedings where that person within those proceedings elects to give evidence. Now, it makes perfect sense in those circumstances that the person is not then entitled to refuse a question, to answer a question, or even produce a document or thing that on the basis that it would tend to prove the commission by the person of the offence for which he's there charged. So in other words, if you submit yourself into the witness box in defence and the prosecutor plainly and clearly says, I put it to you that you are guilty of this offence, then you've got to answer. It's as simple as that. Presumably the answer would be, no, I'm not guilty, given the plea. So, but the point is that the person is not entitled to refuse to answer the question in those circumstances. But the person is not to be asked, or if asked, is not required to answer any question that tends to show the person had committed or been convicted of or charged with any offence other than that for which he's there charged, or is of bad character. And that makes sense, doesn't it? So if you're there on a charge of rape, the prosecutor can't say, well, I'm going to take this opportunity to ask about a burglary that we're interested in and we think he's guilty of if it's unrelated. He's not charged with that, so it's not relevant. So the usual rule about self-incrimination applies to the burglary charge in that situation. Likewise, questions about bad character, they can't be asked either, but there are some exceptions to both those things. So we're now dealing with the exception to the exception to the exception, if you understand what I mean. So what are the exceptions? When does a person have to answer questions in relation to matters other than that for which he's been charged in the proceedings or of bad character? The first is where the question is directed to show the manner in which the proof is admissible evidence to show the person is guilty of the offence for which they're charged. In other words, there can be a question that goes to establishing building blocks that relate to that particular charge. So if the burglary charge was some way relevant to the rape charge, then the person may have to answer the question. The defendant may have to answer the question, for example. Another exception, if the question is directed to showing a matter to which proof is admissible evidence to show that any other person charged in that proceedings is not guilty of the offence, or if the person has personally or by counsel asked questions of any witness with a view to establishing the person's own good character, or has even given evidence of good character, or the nature or conduct of the defence is such as to involve imputations on the character of the prosecution or any witnesses for the prosecution, then the witness is liable to be subjected to questions in relation to their character. And of course, one of the big things about someone's character is their criminal history. So if you run a positive defence where you are supporting your good character and you are attacking or potentially attacking the character, the bad character of the prosecution witnesses, if you give evidence, then you may find yourself compelled to answer questions in relation to your own character as defence. And finally, if the person has given evidence against other persons charged in that criminal proceedings, then of course they can be asked questions about their character as well. All right, so you'll need to read sections 10 and 15 carefully so that you have a good understanding of the general rule against about the privilege against self-incrimination, and then the exceptions that are outlined in section 15 and the exception to the general rule as outlined in section 15. So as I said, this dealing with the rule, the exception, the exceptions to the exceptions, if you like. Let's move on to a different topic, and that is the use of a statement given involuntarily. Now, if a witness is forced to give evidence, for example, if having claimed privilege and then it's denied, the answers that they would that they give would not be admissible in later proceedings because they're regarded as involuntary answers. So again, we're getting into the area of bunning and cross. This is a really important case. You'll come across bunning and cross often, and it's in the context of fairness. So bunning and cross, 1978, 141 CLR 54. Legal professional privilege. The common law governs legal professional privilege. The Queensland Evidence Act doesn't change that. And privilege is claimed in areas about seeking and receiving legal advice and preparing items for use in actual or contemplated litigation. As Justice Kirby said in Daniels Corp International against ACCC, 2002-213 CLR 543, the privilege against self-incrimination is regarded as a human right. Legal professional privilege is a right that will not be taken to have been abolished by the legislative provision except by express language or clear and unmistakable implication. In other words, before legal professional privilege may apply, the parties need to be in a relationship of lawyer and client, and the communication has to be fairly referable to that relationship. But once it applies unless there's a very clear statement to the extent that it is abolished by legislation. Now, just on that topic of the statement having been made within the context of a lawyer-client relationship, it's an interesting case of R against Williams, the Crown against Williams, 1999 QSC 185. And the court held in that case that the privilege did not apply to a conversation between a female legal aid Queensland employee and a man that she met through a dating agency. He mentioned his marital problems, said he'd be better off with his wife dead, and then he was later charged with his wife's murder, and the court held that his statement was not privileged, even though the recipient was a legal aid employee. I hope that makes sense. So the context in which the relationship occurs is entirely relevant. There's a few cases to do with in-house counsel. Have a look at Waterford against the Commonwealth. That's 1987 163 CLR 54. And the High Court held that the legal professional privilege extends to communication passing between government departments and their in-house lawyers if other elements of the test are satisfied. So that can be the privilege apply there. Also look at Telstra Corporation against Minister for Communication, Information Technology and the Arts, 2007, FCA 1445. The Federal Court will allow a claim of privilege if personal loyalties, duties and interests of the in-house lawyer do not influence the professional legal advice the lawyer gives, and the requirement for independence must be satisfied. Again, in your textbook, some commentary about fraudulent or unlawful purpose, and you'll see the cases there. Cox and Railton is the first one. The privilege does not cover a document drawn innocently by a solicitor intended by a client to be used as a fraud or for fraud. So that's an exception. R against Bell, ex parte Lees, 1980 146 CLR 141. The court held that a solicitor is obliged to reveal confidential information relating to the whereabouts of a child, the subject of family court custody orders, because the privilege could not be used to frustrate the process of the law. It's a really interesting case. I think that's, to my mind, that really is borderline. However, I could understand the ultimate reason for that decision. Finally, R against King, 2002 SASC 140, so it's South Australian Supreme Court 140. The privilege was denied regarding false information given by a client to his lawyer in an attempt to persuade the Director of Public Prosecutions to discontinue a criminal charge. There is some commonality between these cases, and that is that the lawyer may be completely innocent of the facts that make the client's objectives criminal or otherwise unlawful, but still the privilege may be lost in those circumstances. In the civil sphere, in terms of documents, there is the dominant purpose of the privilege test, and in that regard, you'll need to consider two cases. I'll start with Grant and Downs, 1976 139 CLR 674. Formally, the privilege could not be claimed unless giving of the legal advice or preparation of the document was the sole purpose for which the document was created. So that's Grant and Downs. But that was overturned by the High Court in ESSO Australia Resources against Federal Commissioner of Taxation, 1999 201 CLR 49. And the test now is whether the legal advice or preparation of documents was the dominant, but not necessarily sole, purpose for which it was created. And that's an interesting case for a couple of reasons. It establishes now the clear test about documentary privilege in civil matters, the document being created, the dominant purpose of it being created for preparation of litigation matters. But it's also interesting in that it shows that the High Court will, in appropriate and necessary circumstances, simply overrule a previous decision of the High Court. It's not bound by its own decisions. One thing to always bear in mind when you're dealing with evidence matters is that we must consider going beyond the Evidence Acts, Commonwealth and Queensland, because other laws do apply. For example, in Queensland, we have the Uniform Civil Procedure Rules, 1999. Consider Rule 429. Now, in theory, the privilege extends to communications with a third party assisting in preparing for litigation. that is the documentary privilege rule involved in documents prepared for litigation. Rule 429 requires the parties to disclose the general substance of an expert's proposed evidence within a certain number of days after closing of proceedings, or pleadings rather. So that is a disclosure obligation, if you like, even though it is a document prepared by a third party specifically for litigation purposes. I hope that makes sense. So what we're talking about there is the person, the party that prepared the document will also be a relevant consideration. Now, how can you lose this privilege if you once have it? It can be lost or waived by, for example, inadvertent disclosure. Or the client may expressly waive the professional privilege, but it's not for the lawyer to waive the privilege. We know that. The barrister in Victoria had no right to waive the privilege. A relevant case is Spalding against Radio Canberra, Pty Ltd, 2009 380 CLR 105. And what this is really saying is once the client waives the privilege, they may never reclaim it in relation to that communication. So when a witness refreshes their memory from a document that was previously privileged, Spalding's case says that the whole of the document becomes the subject of an implied waiver, and not just those parts used to refresh the memory. So be very careful about waiver, inadvertent disclosure, or implied waiver, as was the case in Spalding. And an implied waiver may also arise even if part of the document is reproduced in an open letter, that is one that is not headed without prejudice. And I trust that you understand the difference between open communication and privileged communication, which is intended to be created for the purpose of settling or attempting to settle a matter. Now, in the context of inadvertent disclosure, have a look at the case of R against Tompkins, 1977-67, Criminal Appeal Reports 181. So what happened? This is really interesting. You could just picture this happening in a trial. Now, Tompkins attempted to pass a note where he admitted perjury to his counsel during a trial. You can picture that. The note fell on the floor, and this is a bit surprising. Crown Counsel picked it up and used it for cross-examination purposes, and the court held that Tompkins had lost his privilege in the document because it had fallen to the floor. It's a bit scary, that. And I'm not sure that too many prosecutors, Crown prosecutors, would be quick to seize upon a document in those circumstances. But anyway, Tompkins would be the authority. Have a look at the Evidence Act Commonwealth, sections 118 through to 125 inclusive, and they deal with client legal privilege and also deal with confidential communications. So when I talk about confidential communications, we're really talking about those things that are headed without prejudice. A variation on that is without prejudice, save for costs, call to bank, and I'll talk about that shortly. So what's this without prejudice communication? It's an attempt to claim a privilege. It only applies to civil litigation theoretically, according to your textbook, but in practice, it also applies in criminal proceedings, because case conferencing is now part of the legislative framework for trying to resolve issues to do with criminal law litigation by negotiations in a formal sense between defence and prosecution. And also, we have restorative justice principles, so justice mediation, that applies in criminal law proceedings as well. And those proceedings are also without prejudice, and they're confidential to the process of justice mediation. That's something that I deal with in some length in laws 12062, alternative dispute resolution. But theoretically, without prejudice applies to civil litigation, but it does in reality go beyond that. And so what does the without prejudice communication cover? Well, only admissions. And it's not restricted to communications by lawyers. It can be communications between the parties. For example, look at Rogers and Rogers, a family law case. And it even covers admissions made for reports produced by third parties in an effort to reach a settlement, but subject to the earlier provisions that I mentioned today. And it covers attempts to negotiate even before litigation has begun. Once again, look at Rogers and Rogers. So what was this case, Rogers and Rogers? Well, it's 1964, 114 CLR 608. Prior to litigation, a couple that were separating entered into a lot of correspondence between themselves and through their respective solicitors. So the correspondence was going through two different channels at the same time. And during the communications, the husband disclosed considerable detail regarding his financial position. And the High Court held that the family court should not have used that information as the basis for making an award in favour of the wife. Now, although the parties had not headed their correspondence without prejudice, the High Court held that they had clearly been attempting to reach a settlement ahead of litigation, and on that basis, notwithstanding the lack of formality, that which was disclosed by the husband should have been regarded as confidential and not considered by the court. So whilst you should, in practice, include a reference specifically to your communication being without prejudice in appropriate circumstances, the lack of those words will not necessarily be fatal. Refer Rogers and Rogers. However, there are exceptions to the operation of the privilege. The privilege, that is the without prejudice privilege, will not apply, at least fully, in some circumstances. So we've already talked about waiver. That's one exception. Number two is it won't apply to prevent, it won't apply if it's necessary to produce it to prevent a court from being misled. Also, the privilege will not apply to enforce a concluded agreement so as to ascertain the true position between the parties. In your text, have a look at Walker and Wiltshire. You don't need to find the original case. It's 23 QBD 335. And that case is authority for the proposition that if the terms proposed in a without prejudice letter are accepted, then a complete contract is established, and a letter, although written without prejudice, operates to alter an old state of things and establish a new one. And finally, I mentioned, this is an exception to without prejudice, I mentioned Calder Bank offers and this issue of without prejudice save as to costs. Now, when one party, so without prejudice communication is generally designed to assist the parties in resolving a dispute litigation through negotiated settlement. And it's very common for a party to say, without prejudice, save as to costs. And the idea of that, which comes from the case of Calder Bank against Calder Bank, 1995, 3 All ER, All England, 333, is so as to preserve the ability to ask for costs as from the date of the provision of the Calder Bank offer in circumstances where the party extending the offer has achieved up to or better than the offer that was rejected by the other party. So if, for example, in a we have a situation where a plaintiff sues for $500,000, but by specific communication writes to the opponent and says, I will, without prejudice, save as to cost. I will accept the sum of $300,000 if paid within 14 days. and I reserve the right to produce this letter if successful. Let's assume the matter goes to trial and the plaintiff doesn't recover the full claim of $500,000, but does recover $400,000. Therefore, that is better than the offer which it had extended to the other side. The successful party in those circumstances is entitled to produce the call-to-bank offer to the court when arguing the question of costs to say, not only should we receive the usual statutory, if you like, party and party costs as from the date that the offer was made, we should in fact receive indemnity costs because the other side should have accepted our offer of $300,000. By failing to do so, we've had to incur additional legal expenses, and we believe that the other party should pay all of those legal expenses on an indemnity rather than a party and party basis. I hope that makes sense. In the Commonwealth jurisdiction, have a look at section 131 of the Evidence Act. There is a general prohibition reflected in that section against the provision of evidence of settlement negotiations. And section 131 says that evidence is not to be adduced of any communication made between parties in dispute in connection with an attempt to negotiate a settlement of the dispute, or any document associated with that, or any attempt to negotiate a settlement of the dispute. There are some exceptions. It doesn't apply if the party consents or tenders, or the substance was disclosed anyway, or it tends to conflict direct evidence, or contradict evidence, or to enforce an agreement, or avoid misleading a court, or relevant to costs or fraud or deliberate abuse of power. So there are many exceptions to the rule, but the general rule is that evidence is not to be adduced of communication between the parties. And section 131 does not exclude, that doesn't apply to an attempt to negotiate a settlement of a criminal proceeding. The next privilege that you'll read about in your text is public interest immunity, once known as Crown privilege. And the idea is that it covers matters of national security. Dunkel against Camel Laird, 1942 AC 64, so this is an English decision. The High Court refused disclosure of design plans of a British submarine during World War II on the basis that that material was privileged in the interest of the public and therefore should not be disclosed in open court. Makes sense in the middle of World War II. Refer also to Spencer against the Commonwealth of Australia, 2012-207 FCR 39. The Federal Court reports. So the full Federal Court emphasised the sanctity of state papers. Now, when the immunity is claimed and there's no apparent ground for concluding that the interests of justice required disclosure, the trial judge is not even required to inspect the documents under which the privilege is claimed. Consider the situation also in criminal cases. Now, an example of where the privilege was not upheld was R against Hayden, 2005 SASC 16. This was a case involving the Snowtown murders. Do you remember that case? 8 bodies were found in a bank vault. Now, the issue before the Supreme Court in South Australia was whether the accused could obtain information about 2 witnesses against him who were registered police informants. And the court determined that the evidence of the informants was important in the case. The credibility and reliability of their evidence was a major issue, and therefore the court ordered the Commissioner of Police to disclose the information, which is not good news if you are a registered police informant. The privilege was upheld in the case of Harms against Queensland Parole Board, 2008 QSC 163. on the basis that the disclosure would put a person at risk. And the Supreme Court of Queensland had to balance the right of a serving prisoner to provide procedural fairness against concerns about safety of a person who provided information to the parole board. And the court ruled against disclosure because it might put innocent individuals at risk of reprisal. So that was Harms against Queensland Parole Board, where a contrary conclusion was arrived at by the court, contrary, that is, to the conclusion in Hayden's case. Also look at Section 8 of the Evidence Act, witness in criminal proceedings. Each person charged is competent but not compellable. We dealt with that earlier. Also consider the husband and wife. They are competent and compellable in Queensland. We talked about that earlier. An interesting thing is to do with clergy. And in Queensland, communications between member of the clergy and congregation are not privileged. Now that's different to the Commonwealth position, where Section 127 of the Evidence Act specifically provides for religious confessions, except made for a criminal purpose. Let's move on and talk about some issues to do with the examination of witnesses. Thank you again for participating in your exercise to do with examination and cross-examination of witnesses. In reality, the procedure is in Queensland that a trial on indictment commences through the Magistrates Court, even though it is likely to result in the finalisation of the matter in the Supreme or District Court. But it usually starts in the Magistrates Court, and the role of the magistrate is to determine whether there is sufficient evidence to warrant the matter being dealt with by the higher court, and that is through the committal process. So the committal process is where the magistrate asks the question of him or herself, is there sufficient evidence presented to me to suggest that a jury, a reasonable jury, properly instructed, could find the person guilty of the offence? So it's a very low test, and therefore it is quite common for magistrates to commit individuals in those circumstances to appear on trial. The rules have changed dramatically in 2010 with the introduction of the Moynihan reforms. The as-of-right ability for defence counsel to cross-examine witnesses at committal was refused or removed, so that now the ability to cross-examine is very tightly curtailed, strictly confined, so that in reality it doesn't happen very much at all. That only applies to only applies to Queensland indictable offences, doesn't apply to the Commonwealth, and doesn't apply to children. Simple offences or indictable offences that must be dealt with summarily are entirely dealt with in the Magistrates Court, at least at first instance. Of course, they may be then subject to an appeal, which would be typically to the District Court. But the trial procedure then is essentially along those lines. For more detail about trial procedure in Queensland, have a look at sections 590 through to 631 capital A of the the Queensland Criminal Code. Now, in your assessment, we dealt with issues to do with examination in chief, where you're asking evidence, and what you're seeking to do is obtain in a logical manner, if you like, the full picture of the circumstances, what this witness knows, material to the facts. And some of the things that are produced may not be material per se, but they might be necessary to paint the full picture. Sometimes leading questions are permissible, but only to a degree. So a leading question is one that suggests the desired answer. He hit you, didn't he? Or assumes a fact yet to be established by the evidence. What did you do after he hit you? An example of a leading question of the first type would be, was the accused carrying a gun? Or even worse, the accused was carrying a gun, wasn't he? Clearly, leading questions. The correct approach would be to ask two consecutive but linked questions. was the accused carrying anything? Not what was the accused carrying, which still implies that the accused was carrying something. And if the answer was in the affirmative, then, well, what was it? Do you understand the difference then between that which is permissible, and I talk about it building blocks in terms of obtaining evidence. So there's generally a ban on leading questions. The question is not leading if it's aimed bluntly at the very heart of the case. So in Crown against Shaw, 1996, 1 QDR 641, the court decided it is perfectly acceptable for a Crown counsel to ask a victim in a rape trial, did you agree to have intercourse with the accused? That is not leading because it goes to the very heart of the case, so it's an exception. There is a ban on previous consistent statements, but there are some exceptions to that. One relates to fresh or complaints made in sexual cases, or we used to call them preliminary cases, fresh complaint, we now call them preliminary complaint. And the second relates to evidence that the witness or the allegation that the evidence being given by a witness is a recent invention. So if there was some evidence that the witness had said this in the past, upon being challenged, it's possible then to introduce evidence of a prior consistent statement to overcome that. In dealing with preliminary complaints, have a look at the Crown against RH, 2005, 1 QDR 180. And what is it? It's admissible as evidence supporting the credibility of a complaint by way of consistency. It operates as an exception to the other common law general rule that the credit of a witness is collateral and should not be pursued. So when it comes to the issue of fresh complaints, courts are now more tolerant than they used to be and recognise that factors such as shock, disbelief, fear or shame sometimes are powerful, valid reasons why a complaint was suppressed, potentially for many years. Now, a really important provision for you to consider is Section 4, capital A, of the Criminal Law Sexual Offences Act 1978, Queensland. So please look at that section. And what it basically says is that in a trial relating to a sexual offence, evidence of how and when any preliminary complaint was made about the alleged commission of an offence is admissible in evidence. This is the important part, regardless of when the preliminary complaint was made. However, in criminal proceedings, the court may exclude the evidence if the court is satisfied it would be unfair to the defendant to admit the evidence. So there is that overriding discretion. And I mentioned earlier that where you've got a jury, the judge may not warn or even suggest that the law regard the complainant's evidence to be more reliable or less reliable only because of the length of time before the complainant made the preliminary or other complaint. Now, of course, that is subject to the Longman direction that I mentioned earlier. Have a look at Section 4A of the Act and have a look at the examples in the Act which talk about the exception, what is meant by a preliminary complaint. So a preliminary complaint means any complaint other than the complainant's first formal witness statement to police or a complaint made after the complaint mentioned in paragraph A. So the example in the section is worth considering. Soon after the alleged complaint or commission of a sexual offence, the complainant disclosed the alleged commission to a parent soon after. So that's complaint number one, preliminary complaint number one. Many years later, the complainant made the complaint to a secondary school teacher and school guidance officer. That then becomes complaints 2 and 3, both called preliminary complaints. The complainant visits the local police station, makes a complaint to police at the front desk, which becomes complaint number 4. The complainant then attends an appointment with a police officer, gives a formal witness statement to the officer in anticipation of the criminal proceedings. That's complaint 5. And after the criminal proceedings begin, the complainant gives formal witness statement, which is complaint 6. Now, each of complaints 1 to 4 are preliminary, and 5 and 6 are not preliminary complaints. So Section 4A makes it clear that there is no time limit for a complaint to qualify as a preliminary complaint, and the judge may not make adverse comment to the jury along the lines that the complainant's evidence is less reliable because of the time delay, but the judge may make comment that is appropriate to make in the interests of justice. And in extreme cases, the trial judge can exclude the evidence if it's entirely unfair to the defendant. Once again, have a look at the bench books, provide some excellent guidance. Find and read and consider the bench book that deals with preliminary complaint, and you'll see that there's some excellent commentary there that deals with that issue. Also consider the Longman direction, which is contained within that, and have a look at the bench book in relation to delay between a sexual incident and a complaint. Now, there is an extension of the preliminary complaint principle to an allegation of assault by police. So it's not just sexual assault. Have a look at R against Wright, 1990, 49, A Crim R 462, where the defendant sought to exclude confession on the basis that he gave it when assaulted by police. He did not complain to a superior officer, and the court said the defendant might lack credibility in those circumstances. Also consider Section 101 of the Evidence Act Queensland, which allows a witness to refer to previous consistent statements during a re-examination if specific allegation of recent invention was put to the witness during cross-examination. Now, on the Commonwealth level, we have similar legislation. Refer to Section 108. Section 101 of the Act says that where in proceedings in a previous statement was made is proved for the purpose of rebutting a suggestion that the person's evidence had been fabricated, that statement shall be admissible as evidence of the facts contained therein, of which oral evidence would be admissible. Also consider refreshing memory, and at that stage we might pick up next time. So thank you for your attendance today. I know it's difficult just listening to me without the interaction, but we will be resuming not on the 3rd of January, the 3rd of January, but we will resume on the 10th of January, 7 p.m. Queensland time. All the best. Bye for now.